Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of government documents. June 20th, Supreme Court opinion, Esteras v. the United States. Alright, Eduardo Esteras, who pled guilty to conspiring to distribute heroin and was sentenced to 12 months in prison followed by 6 years of supervised release. The district court, while he was on the supervised release part of his sentence, revoked that supervised release, citing a prior lenient sentence and the need to, quote, promote respect for the law, unquote, under 18 U.S.C. section 3553A2A, remember A2A, and so imposed 24 months of re-imprisonment. So real quick, before we get too far into the weeds here, 18 U.S.C. section 3553A2A. This is a subsection of the statute 18 U.S.C. section 3553A, which outlines the factors a federal court must consider to ensure that a sentence is, quote, sufficient but not greater than necessary, close quote, to achieve the purpose of sentencing. So, 18 U.S.C. section 3553A2A is a subsection that specifically identifies one of the purposes of sentencing that the court must consider as the need for the sentence imposed to reflect the seriousness of the offense, to promote respect for the law, and to provide just punishment for the offense. So that's where we're getting that promote respect for the law. So basically the district court in this case is saying, Eduardo, go back to prison for 24 months because under this subsection, the sentence must promote respect for the law. All right, back at it. So the appeal went to the Sixth Circuit, and they said, yeah, nothing going on here when considering A2A when revoking supervised release. Then the Supreme Court comes down and says, not so fast, lower courts. You guys are getting this all wrong. It turns out that the Supreme Court finds that you cannot use section 3553A2A in decisions on the revoking of supervised release. There is another section, 18 U.S.C. 3583E, which lists 8 of the 10 section 3553A sentencing factors, but excludes A2A in those listed. So the Supreme Court said, expressio unius est exclusio alterius. The expression of one thing is the exclusion of another, basically meaning that if something is clearly spelled out in a law, then the fact that another thing is not clearly spelled out in the law means that it was not meant to be considered. Here, meaning that 3553A2A was not one of the 10 3553A sentencing provisions included in 3583E, so therefore it should not be used when considering revocation of supervised release. So the court rejected the government's arguments, judgments were vacated, and the case was remanded for further proceedings consistent with the opinions expressed here by the Supreme Court. Oh, what a wild one. All right, Kaimo, keep your mind open, do your own research, form your own opinion. See you next time.